Well, in the short term, if the withdrawal agreement is concluded, it won't mean any change because there will be a transitional period until at least the 31st of December 2020, during which competition law in the UK will be exactly, as far as EU rules are concerned, as it is now. The key question is what will happen after the 31st of December 2020. And again, the withdrawal agreement provides for potentially an extension of that transitional period. And if that happens, again, things will continue exactly as they are now. There are certain things that the UK may do, which it's allowed to do in relation to the UK regime. So it's going to make some changes to the UK merger regime, but those are really independent of Brexit. The key question is, what happens if that withdrawal agreement is not concluded? If we have a hard Brexit on the 29th of March 2019? And the other key question is, what happens at the end of whatever the transitional period turns out to be? And in both situations, I think it is clear that if there is going to be any kind of deep economic partnership between the EU and the UK, one area of competition law is going to have to remain very closely aligned, and that is state aid. It is also clear that antitrust rules in principle will have to continue to apply in the UK, but it will be a UK regime. They're going to have to take on much of what the Commission is doing now in relation to big investigations. There will be a separate merger control regime, independent of the EU regime, and there will be, I'm sure, a number of other changes and possibly some divergence. Very much so. They are preparing hard, as one would expect, because everybody knows there's still a risk of a hard Brexit and no deal. And even if there isn't that risk, they still have to get ready for the moment when we do break away from the Union. Transitional period's ended and we're in a free trade agreement relationship. So they are doubling their resources. They have massively increased the expenditure on the CMA. They are preparing to establish a UK state aid regime, which of course we've never had because that was the exclusive competence of the Commission. They are shadowing cases which are currently underway inside the Commission because if there's a hard Brexit, the UK CMA is going to have to fill what could otherwise be an antitrust enforcement gap. Well, ongoing cases for the moment, if there's a transitional period, will just continue. There will be no change. The Commission will continue doing what it's doing, the CMA will continue doing what it's been doing, and the sectoral regulators the same. But once we have a proper exit date, either a hard exit date of the 29th of March or whatever turns out to be the end of the transitional period or the moment at which the free trade agreement actually starts, at that point there will be an impact on ongoing cases. If it's a hard Brexit, it will be literally a very severe break. So, for example, a merger case, unless the Commission has taken jurisdiction over that case and the 15-day period in which a national competition authority can apply to claw the case back has passed, then the Commission will continue with that case under the withdrawal agreement rules, but on a hard Brexit, the CMA would take that case, and there will therefore have to be preparations made by practitioners to allow for that kind of hard change. If we get a free trade agreement, then I would expect that the impact on ongoing cases would be much smoother and would look much more like the provisions contained in the withdrawal agreement, where it's really clear at what point jurisdiction would pass between one authority and another. Well, if there's a hard Brexit, there's really nothing on that at the moment. I mean, the UK would remain a member of the International Competition Network. We would continue to be members of the OECD, and therefore we would continue to have a forum in which competition authorities would meet. But there would be no formal cooperation arrangement unless one is drawn up after Brexit. And one can envisage that that would be along the lines of the cooperation arrangements between the Swiss authorities and the EU, but there is absolutely nothing to look at the moment of that kind. If we have a withdrawal agreement, of course, in the transitional period, the cooperation just continues as normal, and if that then leads seamlessly to a free trade agreement, again, I would expect that there would be a cooperation memorandum of the kind drawn up by the Swiss authority, because that cooperation is so important for particularly successfully pursuing cartel cases. Well, I think the main change, as I've said, will be the development of a state aid capability. I think that there will, of course, be a separate merger control regime, and it is clear that the UK is going to work on its UK merger control regime in the meantime, which it can, of course, do. And that regime will probably catch many more mergers. Query whether it would have to become a compulsory notification regime, which it's not at the moment. But I also detect the possibility of divergence in relation to antitrust decisions. And I say that because if you look at the draft regulations that have been tabled preparing for a hard Brexit in relation to competition issues, you see that Section 60 of the Competition Act, which aligns EU and UK competition decisions, is going to be repealed, and it is going to be replaced by a section which does maintain some alignment, but also allows, in a number of different respects, for divergence. It's quite clear that block exemptions, new ones, may or may not be adopted, and I think we should expect that there will be a difference that develops over time. Okay, well, I think this is a great conference, and I've been coming every year. It's very good because of the phenomenal range and the expertise of the people who speak here and who you meet, and the construction of the programme is incredibly solid. Everything that you need to see covered as a competition practitioner is covered.